Hi everyone, it's Shade. Welcome back to the video updates. Today I wanted to go over what we call intestacy laws, or the default laws of distribution when somebody passes away without a will. So that's pretty confusing for a lot of people because emotionally people think they're entitled to property that's left by a loved one that's deceased, maybe because they're related by blood, or maybe because they've been living together romantically for years and they believe that they've invested a lot into that person and also invested a lot of money into helping that person accumulate the wealth and assets. So they feel entitled to it, whether rightfully or wrongfully. So this video hopefully will clear things up a little bit and also encourage you to put a will together, or some other not just a will. If you have significant assets, you will need some serious estate planning tools, but definitely a will at the very minimum, because then your wishes will be carried out and you don't leave your assets to the mercy of the default laws. So of course we all think we're going to live forever because we're healthy now and everything's going well, but things do happen in life, and unfortunately some people do happen to die a little bit younger than others and they don't expect it. So there is really not a great determining age to figure out whether you need a will, but definitely if you have kids you should have a will, or if you have significant assets. Of course, significant has different definitions depending on the person that's looking at the word. So really, I think that everybody should have a will if you're over the age of 25, just so that you can tell everybody else that's left behind how things will be handled. It saves them a lot of headache, a lot of guesswork, and a lot of disagreements or fighting. And of course, it also helps them to clear things and clean things up, so that the court doesn't have to get involved for the most part, or just has minimal engagement or minimal role to play. Of course, I would encourage you to get a will if you're older than the age of 25, because usually by that age, once you're done with college or trade school, or at least you're over 21, you're already starting to accumulate things, and those things are typically assets at some point. So maybe you have a car that's already paid off, maybe you have jewelry that you like, or an art collection. Some people have significant 401k accounts. They have real estate, of course, and a lot of people these days do tend to have other things that are important to them. And the reason why I think the will is important is that you get to tell the people that are left behind, what do you want them to do with your stuff? How do you want them to divide things up? And you get to pick who gets what. Because if you don't do that, the default laws sometimes will give your things to somebody that you don't really get along with, or you never really talk to them, or they never really helped you while you were alive. So you don't really want yourself to just go that way. And a lot of people also that you leave behind, they tend to feel like they were jilted in some way because they feel entitled to those things, maybe because they're related to you by blood and they really thought they were supposed to get those things, or maybe because you were romantically involved and you guys invested together, or pooled your money together, and that person was expecting to be able to get anything that was left behind by you, and now they're not able to, just because of the way the law works. And you'll see really quickly once I start going into the charts that it doesn't really matter whether you have children with them, or I mean it does matter, but it may not work in the way that you want. Sometimes if you have children together but they're not married, then the consequences might be different than what you would like. So let me go over the intestacy laws and it will make more sense why sometimes you might end up having your fiance or your romantic interest, for lack of a better term, your live-in girlfriend or boyfriend, they might end up getting nothing even though you've been together for 10 years, just because the law says they're not really recognized. And a lot of the times, of course, your relatives that you don't like might end up getting something that you don't want them to have. because they haven't been talking to you all those years, and now they end up getting the majority of your wealth. And sometimes it's even estranged kids that end up getting the stuff that you don't want them to get. So let's talk about what you can do and how it looks. And of course, you get a will together. And if you have significant assets, you do want to do a more robust estate planning with an estate planning lawyer. So let's talk about how the intestacy laws work. So like I said, if somebody dies without a will, that person still has assets. Most people have assets, whether they think they do or not, because at minimum people own cars that might already have been paid off, or they have personal belongings like jewelry and things like that are actually worth a significant amount of money. So how do you then figure out how to divide things? And of course, people have real estate as well. So you figure it out if they don't have a will by looking at the default laws. So let me go first over a single person that does have kids and how it would look. If a single person would die and the person happens to have children, then the intestacy laws, the default law says that all of that person's property, whether real property or personal property, will go to the kids. The person doesn't have a will, even though they have a partner or something like that, as long as they're not married, all of the stuff will go to their kids. The second scenario that I wanted to cover, if somebody's unmarried, so a single person that does not have kids, whenever that happens, you would look up first to see whether they have parents that are alive. If they have parents that are alive, then their parents will get half and half of that real estate or personal property. If one parent is alive and the other parent is dead, then half goes to the living parent and the other half goes to the siblings of that person. If the siblings are deceased but they have descendants, then of course the descendants of the siblings will get their half. So that's how typically it would work. If you don't have siblings and you don't have any living parents, that's when you start looking at aunts and uncles, cousins, because you have to keep going up first, and then you go on the same level, and then you look down. So up meaning you look at the parents first. If none is alive, you look at the same level, which will be the siblings. If none is alive, you go down to their descendants. And for the people that don't have siblings, you just look at the parents' siblings and their descendants. So that's pretty much the easy way to keep those things in mind. The more common scenario that we get is when somebody is married, so they do have a spouse, whether they're separated or still getting along well, they have a spouse, but they just happen not to have a will. And so sometimes they have personal property and then they have real estate. So when you look at personal property, it's treated similar to the real estate if it's separate property. So I'll define that for you. Separate property just means that that's the property that the person brought into that marriage. They already had that property before they got married to that spouse that they have now, or they were married but they inherited that property from their own bloodline, from their family members. So that would make it separate property. Or sometimes it's separate property because we had a prenup and we agreed to keep things separate. So that will be separate personal property or separate real estate, depending on what the person left behind when they died. If there is separate personal property, the children will get 2/3 of the personal property, believe it or not. And then that spouse that they left, that's the surviving spouse, will get 1/3 of the personal property. So imagine having a very nice car that's paid off and now the children are asking the spouse that they need to get the car because they have 2/3 share of that vehicle. So it makes everything kind of wonky, for lack of a better term. So it's best to have a will and just let them know who's supposed to get what. If you love your vehicle or you have a child that helps you fix things up, maybe it's a vintage car, and you really think that that's the only child that would value it and not sell it off, then it's better to have a will and just make sure you convey that vehicle in your will to that particular child so that it doesn't go to your spouse. So it really depends on the scenario and the circumstances. But I just wanted to give you that example to make it make sense to you. And then if it's real estate, it's similar but a little bit different. So let's say it's separate property that you brought into the marriage because you already had this condo or this house before you married this particular spouse. Then that spouse gets none of the real estate. The children get, your children get all of the real estate, but your spouse has 1/3 life estate. Okay, so the children get the fee simple, which is the actual core of the real estate, the actual title. They have 2/3 right to the property while the spouse is alive and living there. But once that spouse moves out of that property, the children own it 100%. So it's a little confusing for people because there's fee simple and then there's life estate, and then that spouse can choose to live there until that spouse dies. If the spouse decides to live there until he or she dies, then the children don't have any choice. They have to wait. If the spouse decides to move out and offers to the children to move out just to make it convenient for the children, they might be able to work something out where the kids pay that spouse the value of that life estate. And there's a calculation for it. It's very complex. I cannot cover it in this video, but it's worth something, of value, of course. And then they can pay that spouse that amount and the spouse can move out. So that's another way to work things out. But because in real life people don't tend to really get along well, it might be very challenging to even get to any kind of solution. So the separate property is treated that way in Texas. What about community property? And community property is what we're defining here as joint property that you accumulated during your marriage. So sometimes it's your retirement account because you didn't have that job until you met this spouse, and sometimes it's the house that you purchased together while you were married. So it really just depends, and sometimes people do buy cars together. So who gets what? When it comes to community property, the spouse is luckier, right? It's better for the spouse in many ways, but of course if you want your spouse to get all of it, then you'll have to have a will. So when it's community property, instead of the spouse getting the whole house, if it's real estate, the spouse only gets 50% of that house. Unfortunately, I mean, they just get their share, really. And then the other 50% will go to your children, but that's only if you had children that are not children of that particular spouse. So let's say you married the spouse and you never had kids yet, and then you both had kids together within that marriage or adopted kids together, then your spouse actually gets 100% of the real estate, which I think is okay with most people. That's the result that they're looking to get. But this part confuses people because they always think in their mind, how come some families are able to get shares of real estate when their mother dies, and then I'm not able to get it now that my mother died? Well, it's probably because all of you kids belong to that marriage. All the kids that that person ever had, they had with that spouse. So that spouse gets 100% of the real estate. If, say, there are other kids that they had, and then they had, maybe 2 children before they got married, and then they have 2 children within this marriage, then 50% of that house will go to the spouse, which is that spouse's share normally. And then 50% of the deceased spouse's share, which is 50% that belongs to the deceased spouse, will go to all the 4 kids. The 2 kids from before the marriage, and then the 2 kids that they had during the marriage, so that that spouse actually gets nothing of the deceased person's share. So that's how it works. Well, let's say you're married, you have personal property and it's community property. How is that figured out? When it's community property and it's personal property, then all of it goes to your spouse. And then there are people who are married but they don't have children. So what happens then? If somebody is married but the person did not have kids when he or she died, then half of that person's real estate will go to that person's spouse, just as we did in the last scenario. but then the other half will go to their bloodline. So the bloodline starts from up, like I said before, so they look to see whether the person has surviving parents. If they have 2 surviving parents, the 2 surviving parents will get a quarter each, and the spouse gets the half that the spouse would have. And then if there's only 1 surviving parent, then the spouse still gets half. The 1 surviving parent will get a quarter, and the other quarter will go to the siblings of that deceased person. Of course, if the siblings are not alive, it goes down to their descendants, and that's how that would work. So let's say somebody is married, but the person doesn't have kids, then all of that person's personal property would go to the spouse, whether it's separate personal property or community personal property. I know this has been a mouthful because it's very, very difficult to wrap your head around, even as a lawyer, what I just discussed, and hopefully that helps you. And this is for educational purposes. I think if you have questions, you definitely need to talk to a lawyer to clear your questions up, because these are straight up scenarios. Sometimes family dynamics are more complicated or complex. So I may not be able to cover all of that within one video that I'm putting out, just to help you to realize that it's a lot more complex than you think it is. And that's why when you hear a neighbor or a friend discussing how their case went, yours might not go that way. We have a lot of cases where we have people that end up co-owning vehicles with people that they don't like just because of the intestacy laws, or they happen to co-own a house with the children of their deceased spouse who had never talked to them for years. So that's why I'm just putting this out, to let you know you should put together at the very minimum a will. If you don't want to put a will together yet, you can definitely have a survivorship agreement that allows your real estate to pass to the person that you've picked while you're alive. So those are my suggestions, and thank you for watching as always.